Good morning. The Subcommittee of Water Resources and Environment, Subcommittee of Transportation and Infrastructure will come to order. Today we're having we're calling it a Part 2 hearing of EPA mining policies and the effect on jobs in Appalachia. I'll start with an opening statement. Welcome again. The Appalachian region is being subjected to an unequal treatment under the law by the Environmental Protection Agency for the arbitrary reason that it produces domestic source of energy. The United States consumes 1.1 billion tons of coal every year. 33% of this coal, or approximately 390 million tons annually, comes from the Appalachian region of the United States, and 50% of the power generated in this nation comes from coal as its fuel source. Coal is an abundant and domestic source of energy. Its use does not subject to the whims of foreign cartel, nor does it tend to thrust us into international conflicts. In addition, using domestic coal creates American jobs. It is clear that coal will and must remain a major source of energy well into the future, and therefore it is important that we keep coal as a safe and inexpensive alternative to other energy options. But to quote one of our witnesses from last week's panel, Michael Gardner, General Counsel of Oxford Resources, one of the job providers harmed by the actions of the EPA. And these permit applications literally fell, as he quotes, "These permit applications literally fell into a black hole where no information was forthcoming, literally the opposite of transparency. You couldn't find out why a permit was on the list. You couldn't find out how to get them issued off the list. This was a de facto moratorium on Section 404 permits. So much for transparency and the EPA enhanced coordination," end quote from Michael Gardner. I'm extremely concerned how the administration is attempting to short-circuit the process for changing substantive energy agency policy under the Clean Water Act without following the proper, transparent rulemaking process that is dictated by the Administrative Procedures Act. This act lays out a process for public comment, making amendments to policy, for states to object, and for judicial review. By ignoring the Administrative Procedures Act, EPA is changing the Clean Water Act and is implementing regulations through means of interim guidance, interim rules, draft policy, or reinterpretation of policy. EPA is taking these actions with little regard to economic consequences, with little regard to national security, and most importantly, with little regard to the law. Much of the Clean Water Act is a delegated program. Through its practices, EPA is usurping the role of the states. At last week's hearing on this issue, the committee heard from 2 state regulators on the issue of EPA's legally dubious interpretation of the law. As Teresa Marks, representing the Environmental Council of the states, the 50 state departments of environmental quality agencies, said last week, and I quote, "Requiring states to implement interim guidance puts each state in the position of deciding whether it will break the federal law or state law. At the very least, this should be a good enough reason why a federal agency should never ask a state to implement something that is not final," end quote. Even though EPA is very much involved in the permit application process with the states, the Corps of Engineers, and other federal agencies, EPA is now revoking permits that have already been issued. This is not legal. In addition, revoking a permit after it has been issued is an arbitrary and irresponsible way for government to act. I consider this regulatory overreach to be a fundamental property rights issue. This is an example of government that thinks it has no limitations on its power. What does it really mean to get a permit? What does it mean to get a final decision from the federal government? If an agency is given the right to unilaterally revoke an already issued permit, then nothing can ever be considered final. The issuance of a federal permit should come with some certainty that the activity can go forward unencumbered, but within the bounds of the permit, particularly those activities on private lands. This no longer seems to be the case, and it is going to have a stifling effect on not just mining operations in Appalachia, but on the economic development nationwide. I would like to close my statement with a quote, as our committee ranking member, Mr. Rahal, eloquently said last week, and I quote, "EPA has a legitimate role to play in the Clean Water Act permitting process. And early on in this administration, many had high hopes that the EPA would provide the clarity and the certainty that coal mining constituencies throughout Appalachia have been asking for, pleading for, and for many years. Unfortunately, we have been disappointed as a result of the guidance that the EPA issues in April of last year. Guidance with far-reaching consequences that was made effective immediately without the opportunity for the public comment. Instead of offering that clarity and certainty, the regime set forth by the EPA has thrown the entire permitting process throughout the region into utter turmoil. End quote from Ranking Member Rahal. I welcome our witnesses today, and before we move to our witnesses, I recognize Ranking Member Representative Bishop for an opening statement.